Hi friends, welcome to my YouTube channel Law Days with Reshma. Today we may discuss about adoption under Hindu law. Adoption is regulated by Hindu Adoptions and Maintenance Act 1956. The person who is adopting a child must have capacity and a right to take a child in adoption. Section 7 of the Act deals with adoption by a male and Section 8 deals with adoption by a female. According to Section 7, any male Hindu of sound mind and who is major has a capacity to adopt with the consent of his wife. On three conditions, wife's consent is not necessary. That is, if she has completely and finally renounced the world, or ceased to be a Hindu, or has been declared to be of unsound mind by a competent court. According to Section 8, the same conditions are applicable in case of adoption by a female. An unmarried woman and a divorced woman can take a child in adoption. Now, when a male takes a son in adoption, he must not already have a Hindu son, son's son, or son's son's son living at the time of adoption. If he takes a daughter in adoption, he must not have a Hindu daughter or a son's daughter living at that time. If he takes a daughter in adoption, the adoptive father must be at least 21 years older than the person to be adopted. The same features are applicable in case of adoption by a female. Now, let us see who may give a child in adoption. According to Section 9, it may be by father or mother or the guardian of a child. Section 10 deals with qualifications necessary to make the child of adoption fit for being taken in adoption. The child, male or female, must be a Hindu. If a child has already been adopted by a person, then that very child cannot be taken in adoption again. The adoptee must be below 15 years of age and unmarried, unless the custom permits otherwise. There is no prohibition on the adoption of an orphan child. He can be validly adopted. Section 17 prohibits receipt or agreement to receive or the giving of any pecuniary advantage of payment of any kind in consideration of an adoption.